How can applying for readmission after dismissal land you in jail? Universities, especially in serious disciplinary matters, often require students to submit written reflection statements as part of sanctions or readmission. These are framed as growth exercises. Describe what happened, identify poor decisions, explain how your behavior violated expectations, and what you've learned. The tone demanded is introspective and self-critical, and students are told not to defend themselves or question others. On paper, this is educational. In reality, it is a compelled narrative written under pressure, where acceptance of responsibility is rewarded and denial is punished. Here is the stark reality. Universities say these processes are confidential. Students hear protected. It isn't. It is not privilege. It does not bind law enforcement. It means only the school won't disclose it voluntarily. When they say they will disclose if required by law, that includes subpoenas, court orders, and warrants. If police persuade a judge the material is likely relevant, the school can, and will, turn it over. At that point, what was written as reflection becomes evidence. There is no special shield and no guarantee of context when it's later used. That is why these statements are so dangerous. They are structured to push students toward language of responsibility and causation, language that overlaps with criminal definitions. A student trying to comply may describe decisions and impacts in a way that is later reframed as an admission. A jury will not read it as a school exercise. They read it as the defendant's own words, and that carries decisive weight. The hard truth is this: in many cases, there is no safe middle ground. It is not just that explicit admissions are dangerous. Even general apologies, acknowledgments of harm, or broad statements of responsibility can be recast as conceding the underlying conduct. Once a statement can be read that way, the rest of the case can be built around it. A statement is only defensible if it avoids adopting the university's factual narrative entirely and does not concede disputed conduct, even implicitly. In practice, that often means focusing on matters that do not depend on those facts, such as communication, cooperation, or how the situation was handled procedurally, rather than describing the incident itself. If that cannot be done without drifting into language that could be treated as an admission, then the reality is uncomfortable but clear. There may be no safe way to submit this statement at all. The task is not simply to meet the university's demand for reflection without producing a document that can later be read as an explicit confession. It is to avoid creating a document that can be read in any reasonable way as one. Bottom line, never apply for readmission without a lawyer who understands this.